How does a legal system that was built for the physical world even begin to adapt to a reality that exists only in code? Well, that's really the central question of our digital lives. In this explainer, we are going to explore the concept of virtual legal personality. This analysis, by the way, is based on the works of Professor Vihar Kiskanov.
So here's our roadmap. We'll start with the basics, defining what virtual legal personality even means. Then we'll break it down into its three core parts. From there, we'll dive into the pretty fascinating world of electronic agents and these code-run organizations called DAOs. Then we're going to tackle the ultimate legal question about AI before we bring it all back down to earth and see how these ideas apply today. All right, so before we can get into any of the really interesting stuff, we have to start with the foundation. What does it actually mean for something to have a legal personality in the virtual world? At its core, it's really about the legal system officially recognizing that an entity can act online. But it's not just about having rights, it's the whole package. It means you can use those rights, but, and this is the really critical part, you can also be held responsible when your online actions break the law. It's basically the rule book for our digital society. You know, this whole idea of legal personality isn't just one single thing. It's actually more like a structure built on three really distinct pillars. So let's break down these building blocks of what makes up an online legal identity. So these three capacities, they have to work together. First up, you have legal capacity. That's just the basic ability to have rights and duties in the first place. Second, you need the capacity to act, which is the power to actually use them. And third, you have tort capacity, which is really just the legal term for a liability, or, put simply, being held responsible for your actions. If you take away any one of these, the whole concept of legal personality just kind of falls apart. So what kind of rights are we talking about here? It's actually a pretty fascinating mix. You've got your traditional rights, like privacy, that are now being completely reimagined for the digital age. But we're also seeing totally new rights pop up, like the right to internet access. And what's really forward-thinking is the EU's idea of a fifth freedom, the freedom of knowledge, which they see as essential for innovation. But of course, it's not a one-way street. All these rights come with obligations, like respecting intellectual property. And that brings us right back to that crucial third pillar, responsibility. Tort capacity means you can be held liable for breaking the rules online. But here's the real key. This isn't just about what you do directly. It actually extends to the automated tools you use, what the law calls electronic agents. In plain English, if your bot breaks the law, you're the one who's responsible. Now, that concept of an electronic agent is so important that we really need to spend a moment on it. We are moving deeper and deeper into a world where software doesn't just help us out, it actively carries out legally important actions all on its own. So what exactly is an electronic agent? Well, think of a trading bot that buys and sells stocks completely on its own, or a smart contract that automatically releases money once certain conditions are met. These are automated tools that are used to independently make a legal statement online. They act for you, but without you being involved in every single step. And as you can imagine, this creates a really interesting legal puzzle. How do we even classify these things? There's a serious debate going on. I mean, could an agent be a representative, like a lawyer? Well, the problem there is it doesn't have an independent human will. Okay, what about just a messenger, a nuncio? That doesn't quite fit either, because the agent often forms the legal statement itself. It doesn't just deliver a message. Other ideas, like seeing it as an extended will of the user, run into trouble when you try to figure out where the user's control stops and the agent's own autonomy starts. There's just no easy answer, which really shows how much our laws are scrambling to keep up. Okay, so if a single piece of software poses that much of a challenge, what happens when you build an entire organization that runs on code with no human leaders at all? Welcome to the wild frontier of decentralized autonomous organizations, or DAOs. And this presents a truly fundamental question for our legal systems. Can something that only exists as software on a blockchain, governed by smart contracts and votes from a bunch of token holders, be recognized by the law as a single legal entity? You know, the arguments on both sides are really strong. People in favor say DAOs act with a clear purpose, they can own property, so for purely practical reasons, they need some kind of legal status. But the arguments against are just as powerful. They don't have a physical identity, and that decentralized structure makes it incredibly hard to figure out who's liable or how to regulate them. I mean, who do you sue when the code is in charge? From organizations run by code, we're going to take one final leap into what is probably the most challenging legal question of our time: the legal status of artificial intelligence itself. This is no longer just a theoretical debate in a philosophy class. As AI systems become more and more autonomous and even capable of creative work, the question is being taken very seriously in legal circles. Should we, and how could we ever, grant them some form of legal personality? The arguments here are just deeply divided. On the one hand, you have AI's growing autonomy and its creative ability, which makes it feel like it's more than just a tool. But the counter-arguments are profound. An AI has no consciousness, no free will. Its unpredictability creates huge problems for liability. And that's all before we even get to the enormous ethical questions about what it would mean to grant rights to a non-human entity. All right, after exploring all those questions about the future, let's bring things back to the present for a minute. How does the law currently handle the way that legal entities, like governments and companies, represent themselves online? Well, to make sure there's accountability, there are already clear, regulated methods in place. Governments use single portals for their electronic services. Public bodies are actually required by law to maintain official websites with very specific information. And of course, e-commerce sites are heavily regulated to ensure they clearly identify themselves to you, the consumer, to prevent them from being anonymous. For example, laws like the Electronic Commerce Act are incredibly specific. An online business can't just be some anonymous webpage. It is legally required to give you clear, easy-to-find information about its identity, its name, address, and contact details, all to ensure transparency and accountability. This is virtual legal personality in practice, happening right now. As we've seen, the law is in a constant game of catch-up with technology. But as these automated systems get more and more powerful, the central challenge really stays the same. And it leaves us with this profound question for our future. How do we design a legal framework that embraces all this technological progress while still protecting the sovereignty of human will?